Welcome to the European Law Unbound podcast series. I'm Maria Bartel, Professor of Transnational Private Law at the University of Amsterdam and the co-president pro tempore of the European Law Unbound Society. This podcast series was recorded in Prague during our inaugural conference in September 25, and we are thrilled to share it with you. In these episodes, you will discover fascinating law in Europe research from our many participants brought to life with their fresh impressions and insights from the conference itself. We hope you will enjoy these conversations as we look ahead to our second annual conference coming to Lisbon in September 26. Stay connected with us on LinkedIn to keep up with the latest news, updates and developments from the European Law Unbound Society. We are just getting started and we'd love to have you along for the journey.
Hello, everybody. Welcome to our podcast. I'm your today's host, Jaroslav Denmark, from the Department of the European Studies here at the Charles University Faculty of Law. We have another special episode of our podcast from the conference EU Law Unbound with a very special guest here today, maybe the only guest that has 3 master degrees from law from 3 universities, and it is Hildur Hjörvar from Iceland. Thank you for coming.
Thank you so much for having me.
Could you tell us which universities have you studied and you have master degrees from?
Sure thing. So I did most of my initial studies at the University of Iceland in my home country. I did an exchange at the University of Utrecht. I had a wonderful time. I did a second master's at the University of Strasbourg while I was working at the European Court of Human Rights. And now I've just finished an LLM from Harvard Law School.
Okay.
So a bit of a sampling menu, also known as too many commitment issues to do a PhD. So just collecting master's degrees.
But currently you are working for the EFTA Surveillance Authority in Brussels?
Yes.
And also you're a lecturer at the University of Iceland.
Yes.
So you're in both of the countries, traveling here and back.
I go back and forth quite a bit. I'm lucky that my workplace has quite a liberal policy on teleworking, so I can mix and match quite a bit. I think this is very common actually in Iceland and perhaps in the Nordics in general, that people tend not to just pick one lane and stick with it.
Really?
There's a lot of practitioners that mix in some academia, a lot of academics mix in some part-time judicial work or consultancy, etc. So because it's a small country, it's a small jurisdiction, we don't have that many people, so you get to wear a lot of hats, which I think is really wonderful because I do think that practice and academia complement each other quite well.
Okay, but you consider Iceland as your home?
Yes, that is home, but it's ultimately home. But for now, I'm permanently living in Brussels.
Yeah. So so you are EU citizen per se?
No, I'm not, because Iceland is not in the EU.
I know, but you feel like one.
I feel like a European citizen. That's for sure. And I'm actually I tend to be quite adamant that Europe is not just the EU, although we tend to treat the two as synonymous. I worked for a long time at the Council of Europe and at the European Court of Human Rights, where the definition of Europe is very different from what it tends to be in Brussels.
A big part of Russia is in Europe, right?
Yes, I was there while Russia was still a member state to the Council of Europe, and I was there when Russia was expelled from the Council of Europe. So those were some very interesting times when we dealt head on with the question of what it means to be European. But I think we also deal with this in Iceland because the capital of Iceland is actually on the North American continent, geographically speaking. So, and we had a U.S. military presence in the country until 2008. So it's a very deliberate choice for Iceland to be European.
So what is to be European? Did you have the answer? Because it's the question that the European Union is also asking. What is to be European? Are the Turkish people European, or the state of Israel, are they European? Is it about mentality?
I imagine that that's part of it. I don't think that we can attach the notion of being European to a particular identity or origin. I think a large part of what it means to be European, at least for me, is participation in the European project. This want to develop something greater than each nation state, to want to contribute to a cooperation and an integration of Europe that brings more benefit, more rights, and more freedoms to its citizens. I think that's part of it, but it's a very big question.
Yes, I know. I'm sorry, but although Iceland is not part of the EU, it's very close to the EU thanks to treaties. So
yes, absolutely. So Iceland, Norway, and Liechtenstein have concluded the EEA agreement with the European Union, which extends a large part of the European Union acquis to these three countries. Which applies sometimes with some adaptations, but essentially they are a part of the fundamental free movement rights. They're a part of the internal market, and they are, and were recently recognized actually by the Court of Justice in a judgment just last year, essentially as the closest partners of the EU.
Yes, but you are well aware of the European Union law, as you are a litigator that is focused on the European Union law, and also a researcher that is focused on the European Union law. So, and your research actually that you have presented here today is focused on the European Artificial Intelligence Act or Artificial Intelligence law.
Yes,
so,
indeed.
Let's talk about that a bit. Could you introduce us to your research?
Yes. So what I did at this conference, because this is the European Law Unbound Society, I played a bit with this notion of being unbound and what that means. And for me, what that means is interdisciplinary and experimental approaches to law. And what I brought to the conference was an interactive session that was called Red Teaming European AI Policy.
Okay.
So the concept of red teaming comes from the cybersecurity and military space, and it essentially consists of playing the bad guy in order to identify weaknesses in structures and systems. So there's a red team that acts as an offensive team. It sort of mimics cyber criminals or military adversaries, attempts to penetrate the defenses of an organization or a system and to exploit it. And at the same time, the blue team acts as the defensive team. It tries to counteract the strategies of the red team and to use those attacks to identify weaknesses and to stop or gaps in their defenses. And there's really interesting research and work going on, maybe particularly in the States, that is migrating this framework and this strategy into the law and policy space.
Okay.
So what that essentially consists of is putting yourself in the shoes of an actor within a legal framework, and ideally an actor that might want to exploit or abuse or get away from a particular set of rules or obligations, and then going through sort of a kind of a framework for how to think about the strategy that they might develop, how they could execute that strategy, and what impact that would have on the integrity of the framework that we've established. And so we applied this during my session primarily to the EU AI Act.
But you're talking in your research, you're red teaming European AI governance. My question is, and I think that this is the basis of the research, what the hell is European AI governance?
So that's a very good starting point. So Europe is at the forefront of developing AI regulation, which is a very challenging space in which to regulate. And there are, in my mind, primarily two different avenues that have been taken. There is the Council of Europe's Convention on AI, Human Rights, Democracy, and the Rule of Law. That is a rights-based, technologically neutral, sector-neutral attempt to create sort of broad principles. You could call it soft law. It has a little bit of teeth, I think. I mean, in principle, it is a binding instrument, although it hasn't been ratified by any state yet. We're getting there. It's been signed by the EU and by 16 other states, including Canada and the US.
Okay,
this was
surprising.
Pre-Trump, of course. Let's not remind them. But it's meant to be an international binding legal instrument. Although it has sort of framework obligations, which each state implements in a way that fits their legal structure. And this is very rights-focused, so it establishes basic principles, including human dignity, individual autonomy, equality, non-discrimination, these types of things. And then it establishes procedures and remedies that are to be put in place to protect individuals from AI overreach, and also risk and impact management strategies that states are to adopt.
Okay.
So this is sort of the, broad brush painting strategy that was adopted by the Council of Europe. And this was adopted in September 24. And on the other end of the spectrum, we have the EU AI Act, which takes sort of the opposite approach. It's a much more detailed, much more ambitious legislative attempt to deal with the
more technological approach.
Yes, goes way more into the detail of the technological intricacies. Tries to create a very structured, very clear framework for who has to comply with what obligation and when and how. And of course, drawing up these kinds of frameworks is extremely tricky. And I have every sympathy with the people whose job it was to write and to negotiate the AI Act.
And it's already outdated, so.
and I mean, that's another thing. This is so because this is migrating frameworks that were developed primarily by computer scientists into the law and policy, and especially like tech policy space. We can very much benefit from input from the tech specialists, where indeed, I mean, they see all sorts of loopholes that we don't. We see all sorts of loopholes that they don't. And I think a marriage of law and computer science is very, very beneficial in this space.
Yes. But isn't there too many loopholes then?
I think through the exercise and from what many scholars have identified in their scholarly writing, and also in other attempts at sort of mapping out the what has been termed by experts out of Brown and Cambridge avoision, sort of this type of behavior that straddles avoidance and evasion. There are definitely some points for improvement, and there is vagueness, and there are exemptions that could be interpreted in ways that does not reflect the sort of the aim and purpose of the AI Act. So I'm sure that we will see some implementing regulations that address some of the nuances and some of the critiques that have been brought forth. There's, of course, a lot of this also goes to the enforcement part, because so much relies on self-reporting and self-regulation. And that, I mean, we know this from other spaces, that there are all sorts of possibilities for exploitation there. So it's a very ambitious first attempt to create a wholesale framework that addresses AI. I'm not sure that I could have done a better job, but I imagine that there is still some space for improvement. And the idea of red teaming in the law and policy space is really about sort of front-loading the trial and error process that you have with developing any type of legal framework.
Yes.
Because there's always, I mean, you develop the framework and then somebody figures out a loophole, or there are some unintended consequences, and then there's litigation, and then you fix it 5 years later. And the idea of red teaming is really to preempt this process by putting yourself in the place of the kinds of actors that can be impacted by the AI Act, and going through a certain process in order to preemptively identify these loopholes.
Show the gray areas of the regulation.
Exactly.
So what techniques were used during the red teaming, or how did it go?
Yeah, so I had set up 6 different scenarios. We divided ourselves into groups. It was a secret group project. People were actually quite happy about that. It also makes for a nice break during a long conference, not just sitting and listening.
Yeah.
So it goes to more or less like this. First of all, you define the red team. Who are you red teaming as, and what are their interests? Then you identify the parts of the policy or the system that you could target. Which parts would you want to get around? What is unfavorable to the way that your company or your foundation operates? Then you identify the assets and the interests that would be put at risk by the action that you take. And here is where the fundamental principles developed in the Council of Europe AI Convention really came into play.
Okay.
If those are sort of the basic principles that we want to protect through European AI governance, how are they jeopardized by somebody taking aim at this part of the policy? Then identifying the vulnerabilities in the system that would enable our red team, to employ their strategy. Then essentially we create an exploitation strategy.
Okay.
And they can take many different forms, and there can be a combination of technical solutions and legal solutions and, political and lobbying solutions. Because obviously the various actors that are subject to the AI regulation have a lot of different tools at their disposal that they can employ. And an important part of red teaming is really to be quite ruthless. It's not to be terribly, diplomatic and polite about it. It's really putting yourself in the place of somebody who might really want to exploit and manipulate. So then we map out the key actors that are involved. Who are the stakeholders? We map the resources that are controlled by the stakeholders or required by the stakeholders. Then we map the relationships and the power dynamics between the stakeholders. And finally, we have created a strategy, and maybe a multi-pronged strategy, for how to avoid regulatory burdens, regulatory costs, avoid either falling within the scope of the AI Act or exploiting an exemption, etc., etc.
So there was no actually blue team?
There was a blue team.
There was?
Yes.
Okay.
So this was the red teaming part. And then the groups, they effectively switched their strategies. So each group gave their strategy to the next group. And then the other group blue teamed that strategy.
Okay.
So put themselves in the place of a decision maker, for example, the commission, somebody who's in a place to defend the system, to protect the system, using this method of identifying weaknesses and vulnerabilities in order to develop a strategy for how to address that. So that was the blue team exercise, which consists of 3 steps. First of all, you identify the indicators that this strategy is being used. If companies are wildly exploiting the research and development exemption, or the open source exemptions being exploited, et cetera, how would the decision maker know? What would be the signs? And then you assess the impact of this strategy. Is it fine if this is used in this way, or does it undermine the structural integrity of the whole framework? And then the big one is, how do you mitigate the threat?
Okay.
What legislative or enforcement or other steps can be taken to prevent exploitation? And what resources would you need? And then we had a third step. So you had the red team,
blue team, and then
blue team, and then you have,
conclusion.
As we all know, when you put red and blue together, you get purple.
Okay.
So the final step is purple teaming, and this is essentially where the red team and the blue team share their takeaways, their experiences, the ways in which this kind of thinking helped them to identify weaknesses or vulnerabilities, or change their way of thinking about how we regulate and legislate AI. Of course, and it was it went really great. But as I told the teams, normally a red teaming exercise takes anywhere from a month to like 6 months, and we had an hour and a half. So I wouldn't say that all the teams necessarily got to the end of the road in terms of their thinking, but it was more. The idea was more for us all to come away with some tools, some new ways of thinking about how we develop law and policy.
And could you introduce us to one or two of the scenarios you had for the red team, so the listeners can actually imagine what was that about?
Sure. I will try to. Well, they were quite lengthy scenarios. But for example, there was one group was representing. Well, they were the leadership and legal team of Just Peachy, which is a Romania-based company that sells a managed service for hospitals and law firms. And essentially what I set up was a company that purports to be selling data infrastructure, but is in reality selling an AI system. And it's selling an AI system that is interacting in sensitive areas, including the provision of medical services.
Okay.
And there's a slight discrimination problem in the outputs, And the question is whether the provider of this index, which really probably is an AI, but it's a little bit vague, how they can avoid being responsible for the downstream outputs of the index which they sell to these operators.
Mm-hmm.
So another example was a research foundation registered in Czechia, but which had subsidiaries, one in a commercial subsidiary in Germany, and then a research subsidiary in Ireland, and one which is in a place to exploit the research and development exemption to the AI Act through doing research within one entity, but then using another entity to commercially exploit the product of that research. And they had some, shall we say, questionable practice about licensing something out as supposed open source, but not in compliance with the OSI requirements for so not true open source, but sort of vague open source. So exploiting potentially the research and development exemption and the open source exemption.
Okay. And while doing this red teaming, blue teaming, and purple teaming, was the conclusion related to the Artificial Intelligence Act that the Artificial Intelligence Act is actually a good regulation, or does it have too many loopholes or problematic areas that needs to be still covered?
I think participants in some respects were impressed with the level of intricacy and nuance and precision that has been introduced to at least parts of the AI Act.
Okay.
The parts of it are quite well drafted. And that other parts of it are maybe more open to exploitation. Of course, it's quite a lot to take in within the space of 90 minutes, because there's a whole technical side. And when I rerun this, I would actually love to combine an audience of lawyers and of computer scientists, because I had a lot of sort of potential solutions set up that involved some techie sides, which maybe the legal people. It doesn't necessarily immediately ring a bell. But I think that overall, I think we identified definitely some room for exploitation and manipulation, but also, but not necessarily everywhere where people expected to find it. So I think at least in some of the cases where people thought, oh, we can exploit this and we can use this exemption, actually reading a bit further, they discovered that it wasn't as broadly or as vaguely defined as they thought.
So it wasn't obvious from the beginning. Yeah. So, well, but the Artificial Intelligence Act is quite new piece of legislation. So we still have to see how it's used in the practice and how is it exploited. What's your opinion on the future of the Artificial Intelligence Act?
That's a very good question. I think regulating AI.
You started from the very beginning of.
I think that regulating AI poses not a unique but a special challenge for Europe, in that it requires a balancing of vital interests. On the one end, fundamental rights and freedoms of individuals, which goes to the core of the values of the European Union and of the Council of Europe. And on the other end, competitiveness and being outmatched by non-European competitors. And you can really see this struggle, I think, in the way in which the AI Act has been developed. And I appreciate that a lot of careful balancing has gone into the way that it's currently drafted. I hope that it is successful. And this really is, so the purpose of red teaming is not to tear something down. The purpose of red teaming is to viciously attack something that you care about to make it better. So I'm sure that through these types of exercises and through scholarly writing and, of course, experience as the AI Act is rolled out, because it is still, in fact, taking effect. It will be in full effect as of August 27. In that process, I'm sure that some fine-tuning will be required. And there might be some minor oversights, there might be some major oversights, and of course, technological development. To the extent that it was possible, I think that the AI Act addresses at least, well, I think it's quite forward-looking in the way that it addresses tech, even though it tries to be tech specific. But I'm sure that future developments will require updates.
But well, yeah, there's a follow-up question. Isn't actually the technical regulation, such as Artificial Intelligence Act, sort of disadvantage for the technological development and market in the European Union?
A disadvantage?
Disadvantage, yes, because if we look at the regulation of artificial intelligence in the rest of the world, European Union is exemption. Nobody even tried to regulate artificial intelligence as we did in the European Union. So could it be disadvantage for the development of artificial intelligence in the Europe? Or do we have to do it? I mean, this kind of regulation.
So Anu Bradford has done a lot of interesting thinking and writing on this topic. I don't think that Europe is alone in regulating AI. California's SB 1047 has also developed...
California is usually, or in a regulatory way, California is very similar to European Union. Their approach to the privacy policies or the right to privacy or even right to be forgotten, it's very similar to Europe. But it's, exemption in the USA.
It is, but California is the hub of technology.
That's right.
And business in the US. So, I mean, in effect, I think to the extent that we are worried about the absence of US federal level legislation, I think those worries might be overstated. So in the big beautiful bill that was passed over the summer, there was, I can't believe I have to say that, there was originally a proposal for a 10-year moratorium on state regulation of AI. So effectively the federal government banning individual states from regulating AI. And as I understand it, that moratorium clause was dropped before the bill was approved. So regulating AI in the US has become somewhat of a states' rights issue. Federalism 7.0 or something. they go back and forth in who is trying to wield federalism against the other. So to some extent, I think California legislation will have significant impact on tech and AI development in the US. There is, of course, to some extent, the Brussels effect, and because of the large geographic scope of the EU, of the AI Act, and because of how attractive Europe still is as a market, I think the AI Act stands to have impact beyond just itself. But competitiveness is certainly it's an issue, and it's an issue which we need to address. But I don't think we should be crying wolf. I don't think we need to quickly deregulate everything out of a fear of losing our competitive edge.
I agree with you. Yeah, we are still a very big market. And as you mentioned, the Brussels effect still takes place. And Artificial Intelligence Act just might be might have the Brussels effect we need, as GDPR had, actually.
Yeah, indeed. And then over the course of some time, hopefully not too much time, but some time, we might see that we overcorrected. We might want to pull back a little bit or push further on certain technologies or certain methodologies. But I don't think that regulation is a reason for lack of innovation.
Yes. Thank you very much.
Thank you so much.
Thank you for coming and accepting our invitation.
Thank you so much for having me, and thank you for a wonderful conference. This has been excellently organized, and it's a really rich and dynamic environment. I look forward to returning next year.
Yeah, we'll be happy to. Yeah.
Thank you.